America's criminal justice system is about to reach a flashpoint, one that has already drawn the attention of the White House, sparked new legislation, and torn apart at least one family that will never be the same. Right now, across the country, some of the most notorious figures tied to violent crime are either walking free or standing at the threshold of complete, unrestricted freedom, and some of them struck when they were young. Let's talk about the most dangerous kids set to be released in June 2026. Ronald Exantis, 40 years old, had been sentenced to 20 years in prison in 2018 for killing 6-year-old Logan Tipton and injuring members of Logan's family during a home invasion in Versailles, Kentucky. Exantis was found not guilty of murder by reason of insanity, but guilty but mentally ill on assault charges. That verdict, not guilty of murder while admitting to the killing, is the kind of thing that sounds impossible. It is the kind of thing that, when you first hear it, makes you read the sentence again, twice, 3 times, but it is exactly what happened. And then, things got worse. Investigators said Exantis had driven from Indianapolis on December 7, 2015, before breaking into the Tipton family home while they were asleep. Detectives found it was a random killing, no connection to the family, no motive that made any human sense. He drove from one state, walked through an unlocked door in the early hours of the morning, went to the kitchen, picked up a knife, and walked into the bedroom of a 6-year-old child. Logan's sister Dakota Tipton recalled, "He stabbed me in the back and then stomped on my head, and I remember waking up across the room, not where I was at, and I looked and he was killing Logan, and Logan was screaming." She was a child in her own home, watching her brother die in front of her. Logan's father tackled Exantis and held him down until police arrived. A father had to pin down the man who just killed his son and stabbed his daughters and hold him to the floor until law enforcement showed up, because that was the only way to make sure he didn't escape. According to court records, Exantis was released on October 1, 2025, after serving less than 7 years of his 20-year sentence. Less than 7 years. For a murdered child, 2 stabbed daughters, and a father who had to wrestle a killer to the ground in his own home. Good behavior credits, time spent in jail leading up to trial, and a 6-month mandatory re-entry supervision program added up to nearly 13 years shaved off the sentence. The Kentucky Online Offender Lookup reports that Exantis could be released by June 6, 2026, with good time and jail credit. And by the time you're watching this video, that date may already be here. Logan's father, Dean Tipton, said, "What was there to prove? I caught him. I caught him. He didn't make it out of my house." He admitted it to the detectives. The White House said it was investigating the release of Ronald Exantis, a man who was released from prison 13 years early after stabbing an entire Kentucky family and killing their 6-year-old. White House Press Secretary Karoline Leavitt made the announcement. "It's wholly unacceptable for a child killer to walk free after just several years in prison," Leavitt said. Logan's mother, Heather Tipton, said her reaction was, "Finally. People are finally finding out about this. You know, 10 years ago we tried to get the word out, but social media was not what it is now." Ronald Exantis was rearrested in Florida on October 9, 2025, less than a week after he was released early from his 20-year prison sentence in Kentucky. He had moved to Florida under an interstate compact. As a condition of his mandatory re-entry supervision, arrest documents state Exantis failed to register as a convicted felon after arriving in Florida following his release on October 1. He was also charged with violating the conditions of his release. But here's the part that makes this story so deeply unsettling. Despite the Kentucky Parole Board's decision to keep Exantis in prison, Kentucky law required the Department of Corrections to release him on mandatory re-entry supervision. According to records obtained from the Kentucky Department of Corrections, at every chance the state's parole board denied Exantis' release. He was denied in 2019, 2021, 2023, and on September 30, 2025, one day before his release under the state's mandatory supervised re-entry program for nonviolent offenders. Each of the parole board's denial orders lists seriousness, violence involved, a life being taken, and that the crime involved a firearm or deadly instrument. As to why he should remain in prison, the board said no, again and again. A law overruled them, and a child killer walked out of prison, although Exantis committed a ruthless attack during which he had murdered Logan Tipton. Exantis was not classified as a violent offender, and he qualified for mandatory re-entry supervision. Not classified as a violent offender. The man who stabbed a sleeping 6-year-old to death, not classified as violent under Kentucky law at the time. because of a legal technicality rooted in the split verdict. And that technicality opened a door that should never have existed. Exantus's mandatory re-entry supervision started on October 1, 2025, and is supposed to end on June 18, 2026. At that time, when his re-entry supervision ends, Exantus will be completely finished serving his sentences for the brutal crimes he committed. That is the date, June 18, 2026, the date on which Ronald Exantus, the man who killed 6-year-old Logan Tipton in his bed, becomes a completely free man. To understand exactly how Ronald Exantus ended up walking out of a Kentucky prison after less than 7 years for murdering a child, you have to look at the machinery underneath the verdict, because what happened here was not an accident. It was not the result of one bad judge or one bad decision. It was the product of multiple layers of law, each one interacting with the others in a way that produced a catastrophic outcome for the Tipton family. Dr. Dustin Wygant, an EKU professor and executive director of Integrated Behavioral Health, explained that the insanity statute asks whether, at the time of the crime, the person had a mental condition that impacted their understanding of their behavior. It's an affirmative defense, which means that the defendant has to say, "I did the crime. I did the thing that I'm charged with. But when it occurred, I had some type of mental condition," said Dr. Wygant. Exantus had that. He had been diagnosed with early-onset schizophrenia. During his 6-day trial, the defense argued Exantus was insane at the time of the crime and in a state of psychosis, but both the defense and prosecution admitted that he killed the boy. Exantus was found not guilty of murder by reason of insanity, but he was convicted for the brutal assaults on other family members the night he broke into the home, found innocent for the murder, found guilty for the assaults. The jury, in effect, decided he was lucid enough to be held responsible for stabbing the father and daughters, but not lucid enough to be convicted for killing Logan. It is a legal distinction that, to the Tipton family, meant nothing. Nearly a decade after Logan's death, Logan's father, Dean Tipton, still doesn't understand the not guilty verdict on his murder charge. One of the hardest things I ever had to do in my life was come home and tell my kids that he was innocent from the murder. They're young, they're saying, "Well, how is he innocent from the murder? We watched him do it. We watched him kill my brother." And because of that split verdict, because the murder conviction never landed, Exantus fell into a classification that would change everything about how his sentence was served. Although Exantus committed a ruthless attack during which he had murdered Logan Tipton, Exantus was not classified as a violent offender, and he qualified for mandatory re-entry supervision. The mandatory re-entry supervision law in Kentucky was originally designed for lower-level nonviolent offenders approaching the end of their sentences. The idea was to ease re-entry into society, reduce recidivism, and free up prison space. In principle, the logic holds for the cases it was designed to address, but it contained a gap wide enough to drive a convicted killer through it. Spectrum News obtained Exantus 4-page conditions of mandatory re-entry supervision and interstate compact document. It states he was supposed to check in with a parole officer, find a job, and not use illegal drugs, among other things. That document does not include any provisions stating he should be subject to any mental or behavioral counseling or treatment, despite being found guilty but mentally ill of assaulting the Tipton family. No mental health treatment requirements for a man found guilty but mentally ill. That detail alone caused outrage from commentators, legislators, and mental health advocates alike. Had no such condition attached to his release. Kentucky House Rep. Jason Nemes responded, "He needs to be in an institution. He doesn't need to be out in the streets. He doesn't get to walk. He has to go somewhere. That's what keeps our people safe." Kentucky Parole Board Chair Ladidra N. Jones stated, "Despite repeatedly voting for Ronald Exantus to remain in prison, parole board members have faced significant threats over the last several days, even having their personal addresses released publicly. We are encouraging individuals to take these threats seriously and to prioritize factual information, which is that the board did not release Exantus. Instead, a law passed by the General Assembly did. Even the parole board members who unanimously wanted him to stay incarcerated were being threatened by an outraged public, a public that did not understand that the board had, in fact, said no. The law said yes, and the law won." Rep. Nemes noted that under the Safer Kentucky Act passed more recently, Exantus wouldn't have qualified for the early release program. Instead, it would have required him to spend at least 17 years in prison. However, that law passed after Exantus was convicted. That is the cruelty of the timeline. The laws that would have kept him locked up came too late. By the time they passed, he had already served his time under the old rules, and those rules applied to him. Despite his 20-year sentence, he served 9 years, 9 months, and 25 days. Through an open records request to the Kentucky Department of Corrections, Lex 18 obtained pages of documents detailing Exantus's good time credits in prison. It's mind-boggling. It really is very mind-boggling that there's not accountability, said Heather Tipton, Logan Tipton's mother. According to the documents before trial, Exantus shaved off 2 years and 4 months, with jail credit alone, 2 years and 4 months before the verdict even came in. Then more credits stacked on top. Education credits, good behavior credits, and finally the mandatory re-entry supervision program. By the time it all added up, almost 13 years of a 20-year sentence had vanished. Coral Tipton, Logan's sister, said, "Something needs to be changed because it cannot be that easy. You've committed a very heinous crime, and it's just given to you." That's how the Tiptons see it, and why they hope lawmakers will revisit mandatory re-entry supervision, while also reviewing how much good time can be racked up for certain inmates. And then he walked to Florida. 8 days later, he was back in handcuffs, not because the justice system reached out and grabbed him, but because he failed to register. He essentially gave himself away. Ronald Exantus was booked into the Kentucky State Reformatory in LaGrange on Wednesday, October 29, 2025, after his extradition from Florida. He was sent back, but the clock had not stopped running. Despite being ordered to serve the remainder of his sentence, Exantus could be free again in just months. The Kentucky Online Offender Lookup reports that Exantus could be released by June 6, 2026, with good time and jail credit. The finish line is right there. Part 3. Logan's Law. What it took to change the system. The moment Exantus walked out of that prison on October 1, 2025, a timer started on more than just his supervised release. A timer started on how quickly Kentucky's legislature could react, correct, and ensure that no other family would have to live through what the Tiptons endured. What followed was one of the most rapid, bipartisan legislative responses in recent Kentucky history, and it carried a 6-year-old boy's name on it, Rep. Jason Nemes proposed Logan's Law, which would require people found insane in court to spend time in a mental hospital once out of prison. The basic premise was straightforward. Then the law needs to treat your mental illness, not just release you back into the community with a check-in schedule and a job requirement. Rep. T.J. Roberts issued a full statement. 10 years ago, Ronald Exantus entered a family home in Versailles, took a knife, went into the bedroom where Logan was sleeping, and stabbed the child to death. He then attacked Logan's sisters and father, inflicting serious injuries that changed their lives forever. Although Exantus confessed to the crime, an insanity plea resulted in his acquittal on the murder charge. He received a 20-year sentence on lesser offenses and was later released under Kentucky's mandatory re-entry supervision program after serving less than half his time. The language in that statement became the language of the bill. It named what happened with precision, and it named why it could not happen again. Logan's Law requires that when multiple charges arise from the same course of conduct, a defendant is either sane for all charges or insane for all charges, eliminating split verdicts that allow serious offenders to avoid conviction on the most severe offenses. The bill also ends mandatory re-entry supervision for heinous crimes such as murder, requiring violent offenders to serve their full sentences, unless the parole board unanimously approves otherwise. Think about what that means. The exact mechanism that let Exantus be classified as a nonviolent offender, the split verdict that said he was guilty of assault, but innocent of murder, would be eliminated under Logan's Law. No more. You were insane when you killed, but sane when you stabbed. Either the insanity defense applies to everything that happened that night, or it applies to nothing. House Bill 422 tightens Kentucky's criminal justice laws, extending parole wait times for serious crimes, clarifying who is excluded from re-entry supervision, revising mental illness standards in criminal cases, and making parole ineligibility more clear. House Bill 422 passed through Kentucky's House of Representatives, 93-1 in February, before heading to the Senate floor. In a political climate where virtually nothing passes 93-1, that number is striking. This was not a party line vote. This was a near universal verdict from elected officials who looked at what happened to Logan Tipton and decided, as close to unanimously as possible, that it could not be allowed to happen again. Governor Andy Beshear signed House Bill 422, known as Logan's Law, into law. The bill is named after Logan Tipton, a 6-year-old from Versailles who was killed in his home in 2015. Consider where that man has been for the last decade. He watched his son die. He held down the killer with his own hands. He sat through a trial and heard a jury say the killer was not guilty of murder. He watched credits accumulate. He watched the parole board deny and deny and deny, and then watched the law override every single denial. He watched the man who killed his boy get on a car and drive to Florida, and watched a law get signed in his son's name. And he said, "I wasn't going to rest until it was law." Governor Beshear stated, Logan Tipton was a 6-year-old whose life was cut short through a senseless and violent act. His family has worked in his honor to ensure no family has to suffer like they have. This will strengthen Kentucky's sentencing and parole laws to make our Commonwealth safer and ensure Logan's legacy lives on forever. 90 days after the legislative session ends, according to Logan's Law, defendants who are found guilty but mentally ill would have to undergo mental health checks before being released. A provision from Senate Bill 48, known as Jordan's Law, was added to the Senate committee substitute for HB 422. This provision prohibits an inmate from qualifying for mandatory re-entry supervision if they have previously been convicted of 2 or more offenses that would classify them as a violent offender, or if they have been recommitted to prison for a violation of probation, shock probation, parole, or conditional discharge. 2 separate families' names, 2 separate cases, 1 bill. Kentucky looked at the fallout from the loopholes and closed them, both of them in a single piece of legislation. Logan's family said they are hoping to advocate for a bill like Logan's Law on the federal level, so no family will have to go through what his family has endured. Because right now, Logan's Law only applies in Kentucky. Across the other 49 states, the legal mechanisms that allowed Ronald Exantis to walk out of prison still exist in various forms. Split verdicts still happen. Good time credits still accumulate. Mandatory reentry programs still operate in ways that can override parole board recommendations. Every one of those mechanisms in the right, or rather wrong, combination can produce the same result. Part 4. The broader machinery. How hundreds of violent offenders are walking free. The Exantis case is the sharpest, most painful flashpoint tied directly to June 2026, but it is not the only force pushing dangerous individuals toward release right now. There is a broader, nationwide engine that has been running for over a decade, and its impact is reshaping who is walking out of America's prisons, including people who committed some of the most horrific acts imaginable when they were young. It starts with a Supreme Court ruling in 2012, Miller v. Alabama, 567 U.S. 460, 2012, was a landmark Supreme Court case in which the court held that mandatory sentences of life without the possibility of parole are unconstitutional for juvenile offenders. The ruling applied even to those persons who had committed murder as a juvenile, extending beyond Graham v. Florida, 2010, which had ruled juvenile life without parole. Sentences unconstitutional for crimes excluding murder. Building on decisions in earlier cases like Roper v. Simmons and Graham v. Florida, the court ruled in Miller v. Alabama that mandatory life without parole sentences for persons under age 18 were unconstitutional. The court's decision pointed to decades of brain science. Before handing down the harshest penalties to children, the court ruled states must consider mitigating factors like character, home environment, and the circumstances of the crime itself. In 2003, Evan Miller, the 14-year-old boy whose name became the ruling, had been drinking and using drugs with his juvenile friend in Moulton, Alabama. Miller and his friend got into an altercation with Miller's neighbor after they tried robbing him. Miller and his friend subsequently attacked the neighbor and lit the neighbor's trailer on fire. As a result of their actions, the neighbor died from head trauma and smoke inhalation. Miller was raised in a dysfunctional household filled with violence, neglect, addiction, and poverty. His mother suffered from substance abuse addiction, and his father was abusive. He was exposed to a childhood of instability due to his family constantly changing homes. Miller was arrested and later convicted of capital murder. In 2006, Miller was sentenced to life in prison without the possibility of parole. He was 14 years old. The Supreme Court ultimately decided that sentencing a 14-year-old to die in prison, without even considering the circumstances of his childhood, his mental development, or his potential for change, was a form of cruel and unusual punishment. Mandatory life without parole for a juvenile precludes consideration of his chronological age, and its hallmark features among them immaturity, impetuosity, and failure to appreciate risks and consequences. It prevents taking into account the family and home environment that surrounds him, and from which he cannot usually extricate himself, no matter how brutal or dysfunctional. In 2016, the Supreme Court made Miller retroactive through Montgomery v. Louisiana. That decision opened the floodgates. Every person who had been sentenced as a juvenile to mandatory life without parole, some of whom had been behind bars for decades, was now entitled to a new sentencing hearing. More than 880 people sentenced as children to die in prison have been released since the Miller decision, according to the Campaign for the Fair Sentencing of Youth. Today, a majority of states have rejected death in prison sentences for children. A total of 32 states and the District of Columbia ban juvenile life without parole sentences, or have no one serving a juvenile life without parole sentence. These are real people. Some of them committed murders at 14, 15, 16 years old. Some of them were dragged into violence by older gang members. Some of them acted alone, with full knowledge of what they were doing. The law, post-Miller, does not automatically distinguish between those cases. It requires that each one be examined individually, and that the judge consider the person's youth as a mitigating factor. The recidivism numbers, for what it's worth, tell a complex story. Studies on released juvenile lifers show lower violent re-offense rates than many critics expect. But even a small rate, when the underlying crimes were murders, carries enormous weight for the victims' families who were never consulted, never notified, and sometimes did not find out until they saw it in the news. The behavior of a relatively small percentage of juvenile offenders has had a devastating impact on the public's sense of security, on victims, and on the families of victims. Research shows that, although these serious, violent, and chronic offenders comprise only 6 to 8% of the total juvenile offender population, they account for a disproportionately large number of offenses. Homicides perpetrated by juveniles jumped 65% from 2016 to 2022. Crimes involving 2 or more juveniles were 26% lower in 2022 than in 2016, and solo offending was about 10% lower. Firearm involvement in juvenile offending was 21% higher in 2022 than in 2016, while other weapon use was 6% higher. That last statistic is the one that catches most people off guard. Overall, juvenile offending is down, but the cases that are happening involve guns more often than ever before, and they are resulting in more serious injuries and deaths than the offenses of previous generations. The system is dealing with fewer juveniles who are more lethally armed, and the question of when and how to release the ones who are already inside is becoming more fraught by the year. Juveniles transferred to adult court are 34% more likely to be rearrested than those kept in the juvenile system. Youth under age 13 at the time of their first offense are twice as likely to become chronic offenders. That data point, the 34%, is critical. Exposing them to adult prison culture, stripping away the developmental and rehabilitative focus of juvenile facilities, makes them more dangerous when they get out, not less. The harsh sentence does not just fail to deter. In many cases, it actively manufactures a more dangerous individual. But that is a systems-level argument, and when a specific child killer is about to walk out of a specific prison on a specific date, systems-level arguments feel cold. Part 5, June 2026, The Reckoning. We are now at the point in this story where all the threads converge. The loopholes, the laws, the Supreme Court rulings, the good time credits, the insanity defenses, the parole board overrides. They have all been running simultaneously for years. And June 2026 is where the most high-profile result of that collision arrives. Exantis will serve out the supervised release in Florida, where he's not allowed to leave, until June 18, 2026. On that date, Ronald Exantis, who drove to a family's home, walked through their unlocked door in the middle of the night, stabbed a 6-year-old boy to death in his bedroom, stabbed the boy's sisters, and attacked his father. Becomes a free man. No supervision, No parole officer. No check-ins. The sentence expires, he walks. Coral Tipton, Logan's sister, who was also stabbed that night, said of the White House attention, "I was like, finally, after all of these years, finally. Somebody is grasping about how wrong and cold this case has become, not because we don't know who killed Logan, because we know who killed Logan. He was caught in our house." She said the White House's commitment to review the case and the renewed national interest gives the family hope for meaningful action. But meaningful action, Logan's Law, came after the sentence was already set. The law cannot be applied retroactively to Exantus's case. He goes free under the rules that governed him when he was convicted. Logan's Law will protect future families. It did not save the Tiptons from this moment. Logan's family said they feel blindsided by the release, and plans were underway to introduce Logan's Law to ensure that those found guilty of murder by reason of insanity are not allowed back into society and are instead sent to a mental health facility. Kentucky State Police troopers are investigating threats made to Kentucky Parole Board members after Exantus's release. The rage that this case has produced has been directed in some cases at the wrong people. Now, step back from the Exantus case for a moment, because this is about more than one man. The Exantus case is the sharpest example of what happens when multiple legal mechanisms, each one designed with reasonable intent, interact in ways that produce an outcome nobody in the public would have voted for if they had been asked. The insanity defense exists because some people, when they commit terrible acts, genuinely cannot distinguish right from wrong. The mandatory reentry supervision program exists because evidence shows that supervised reentry reduces recidivism compared to cold releases. Good time credits exist because they incentivize good behavior behind bars and reduce institutional violence. Each one of those things has a legitimate purpose. But when a jury splits a verdict, classifying a killer as not guilty of murder because of insanity, and then the assault convictions leave him classified as a non-violent offender under the law, and then the good time credits stack up and the mandatory re-entry program kicks in automatically. The outcome is a man who murdered a child in his bed walking free in under a decade, with no mandatory mental health treatment, with no requirement that the victim's family be notified until after it happens. The law was prompted by the killing of Logan Tipton in 2015 and the early release of his attacker under mandatory re-entry supervision despite repeated parole board denials. The law expands the definition of violent offenses, requires longer time served before parole, limits early release, reforms the insanity plea, and improves treatment options for severely mentally ill defendants. That is Logan's legacy now. Not just the memory of a 6-year-old who loved his family and woke up every morning with a smile. Dean Tipton said, "He was just a little ball of joy. He was always happy. He woke up and went to bed with a smile. He was just a good, genuine little kid." But also a law that will prevent future families from experiencing what his did. A law that passed 93-1 through a state legislature that rarely agrees on anything. A law that carries his name, signed by a governor standing next to his father. For Logan's father, the new legislation is about accountability. This bill's going to hold everybody accountable. That's the main thing with this bill. You're not going to get free just because you're insane. So it's all about accountability. And like what my dad said, what's right is right, and what's wrong is wrong. The question of whether the criminal justice system can be trusted to keep dangerous people locked up long enough to protect the public is one that cuts across political lines, across generations, and across the divide between those who prioritize rehabilitation and those who prioritize punishment. The data shows that most people who come out of prison, including those who committed violent crimes, do not violently reoffend. The data also shows that when they do, the consequences are devastating and irreversible. For anyone who lives in a community that has experienced high rates of crime for generations, there's not much comfort hearing that things used to be 50% worse. Youth crime isn't something that can be described by abstract numbers on a chart, especially when it has touched you personally. However, when we think about how government and society should respond to crime, especially crime committed by young people, trends do matter. And somewhere in the balance between those two truths, trends matter and individual cases matter, is the answer that no one legislature, no single Supreme Court ruling, and no one law has fully managed to articulate. What we know is this: on June 18, 2026, Ronald Exantis walks free. Logan's Law will never apply to him. It will apply to the next person, and the families of the people who might have been that next person will never know what was prevented, because you cannot count the crimes that do not happen. What the Tipton family can count is what they lost, and what they built from it. Coral Tipton said, "My brother will never be forgotten. Me, my siblings, and my brother will stand on that till our very last days. My brother will never be forgotten, and his name will never go in vain." The law would also strengthen protections for victims' families by ensuring they receive proper notification and have a voice in release decisions. Logan's family said they are hoping to advocate for a bill like Logan's Law on the federal level, so no family will have to go through what his family has endured. That is where this story ends. Not with a resolution, not with justice in any form the Tipton family would fully recognize, but with a law and a name on it, and a father who said he wasn't going to rest until it was done, and it is done. Logan's Law is real. June 2026 is here. The system failed Logan Tipton. His family made sure, at the very least, that the system remembers his name forever.